Good afternoon. I'm Bridget Treacy, and I lead the firm's UK privacy and cybersecurity practice at Hunton Kurth. I'm delighted to welcome you to today's discussion on the implications of Brexit on data protection for US and EU companies. Before we start, let me just deal with a couple of administrative points. This discussion is being recorded, and we'll make the recording available afterwards. If you've got any questions throughout the discussion, please use the Q&A feature at the bottom of your screen to submit your questions. And if time permits, we'll address the questions at the end of our prepared remarks. We also have a code available for CLE credit, and this will be provided during the session. I'd now like to introduce our speakers for today. Joining us for the next hour are David Dumont, a partner in Hunton's Brussels office. David works with multinational businesses on all aspects of EU data protection law, and he has extensive experience helping clients implement data transfer mechanisms, including standard contractual clauses and binding corporate rules. Rosemary Jay is our other speaker. She is a member of our privacy and cybersecurity team based in London. She is widely recognized in this field, having practiced privacy law for more than 25 years. She writes the widely acclaimed book on data protection law and practice, published by Sweet and Maxwell. And the 5th edition of this book, newly revised, completely rewritten, will be published at the end of this month. It takes into account the impact of Brexit on our UK data protection law. You may wish to keep an eye on our privacy blog for more information about this. The publishers are offering our readers a discount code to purchase the book. So with that, let's turn to our discussion today. Our topic today is Brexit and its impact on data protection for US and EU companies. If it feels as though the issue of the UK's departure from the EU has been going on for some time, well, in short, it has. Discussions about Brexit began long before then Prime Minister David Cameron decided in 2016 to hold an in-out referendum on Europe. On the 23rd of June 2016, the British people voted by a slim majority to leave the EU. Before and after the vote, the issue of Brexit has divided our country, and it's led to some fairly extraordinary political and constitutional battles. After a lengthy, messy and fraught political process, the UK eventually left the EU at 11 p.m. GMT on the 31st of January this year. We're now in a transition period that expires at the end of this calendar year. Given the short time that now remains until the end of the transition period, we've seen an increase in questions about the practical aspects of Brexit on data protection. And so we decided to offer today's update. We'll focus on practical issues that arise, questions that people have asked us, we'll explain the legislative changes, and we'll provide an update on the all-important question of adequacy. Is it likely? What will the impact of it be? Whether we get it or don't get it. We'll also examine some of the practical steps that organisations should be focusing on now, in addition to data transfers. So let's begin our discussion by briefly taking stock of the Brexit journey, which will set the scene for our discussion of how this impacts data protection law. I've already mentioned that the vote to leave the EU took place on the 23rd of June, way back in 2016. But the clock counting down the minutes to our departure only started to run on the 29th of March 2017. And the European Commission and the UK government published a draft withdrawal agreement on the 14th of November 2018. This sets out the arrangements for how the UK would leave, and it outlines the political declaration on the framework for the future EU-UK relationship. There then followed months of political negotiations and wranglings, including a change of Prime Minister in the UK and a general election before finally Parliament passed legislation implementing the withdrawal agreement into UK law on the 23rd of January just this year. Following the EU's ratification of that withdrawal agreement, the UK then left the EU at 11 p.m. GMT on the 31st of January this year. So as I've said, we're now in a transition period. This is essentially to allow for trade negotiations. Any deal on this front still hangs in the balance, but irrespective of whether there is a deal to be done or not, the transition period will expire at the end of this calendar year at 11 p.m. During transition, almost all EU law, including the GDPR, continues to apply directly in the UK. But from the expiry of transition, our data protection laws and other laws too will change. Specifically, at the end of transition, the GDPR will no longer apply directly in the UK. UK data protection law will consist of the UK GDPR, which is the GDPR as incorporated into our UK domestic law, plus the Data Protection Act 2018. But that said, the EU GDPR will continue to have relevance here as well. Let's look at this in more detail. As a brief reminder, our existing data protection framework in the UK, for the most part, has three key components. GDPR, which as an EU regulation has direct effect in member states, which included the UK when it took effect. Secondly, the Data Protection Act 2018, which deals with issues reserved by the GDPR for member states to implement under their national law. So in the UK, this includes conditions for processing special category data and criminal convictions data, and quite an extensive number of restrictions to data subject rights. This Act also extends the scope of the GDPR in the UK to areas otherwise outside the competence of EU law. So that's the applied GDPR. It also implements the Law Enforcement Directive. It extends the DPA regime to processing by UK intelligence services. It establishes the Information Commissioner's Office and sets out the powers and tasks of the Commissioner, and it deals with enforcement. And then just to complete the picture, I wanted to mention the Privacy and Electronic Communications Regulations. This implements the e-Privacy Directive, which, as you will know, is currently under review. So how will this change on the 1st of January? Well, in brief, direct EU legislation like the GDPR, and also in this category are formal decisions of the European Commission on the adequacy of third countries' data protection regimes and their decisions approving standard contractual clauses. So all of these instruments in force at the end of the transition period become retained EU law. If you're wanting the statutory reference, they're converted by Section 3 of the EU Withdrawal Act 2018. Retained EU law can be changed, and in the case of the GDPR, it will be amended by regulations nicknamed the DP Brexit regs, but which have a very long title, the Data Protection, Privacy and Electronic Communications Amendments EU Exit Regulations, so the DP Brexit regs. And then these are merged with the applied GDPR, which is the part of the Data Protection Act that extends the scope of the GDPR in the UK. And this whole body of legislation will become known as UK GDPR. So the UK GDPR will capture the EU GDPR as at the 31st of December this year. And it's important to note that if the GDPR is then, the EU GDPR is then amended in future, those amendments will not automatically be incorporated into the UK GDPR. And in fact, they might not be incorporated at all. So, for example, if the EU decided to recognise further countries as providing adequacy, so for example, South Korea, then those countries would not automatically be recognised by the UK. The same would apply in relation to any future privacy shield. The UK would need to make its own adequacy assessment and then take steps to incorporate those countries into the UK regime. Unlike the GDPR, the UK Data Protection Act, so the middle box, is not EU direct legislation, but it's EU-derived domestic legislation, and this also becomes retained EU law. And it will also be amended by the DP Brexit regs, which we'll look at shortly. And note too that decisions of the Court of Justice of the European Union handed down before the end of this calendar year also remain authoritative and binding in the UK as part of retained EU case law. And then for completeness, just note that the position is less clear in relation to e-privacy. You'll know that the e-privacy directive has been under review for several years now and was due to have taken effect as a regulation at the same time as the GDPR in 2018. However, the text has never been agreed and it's still under discussion. Under the current German presidency of the EU, a revised draft text has just been published. And I think, having looked at that, it's apparent that this legislation is unlikely to be finalised before the expiry of the transition period, so it won't form part of EU retained law. Once the e-privacy regulation is eventually finalised, the UK will then need to choose whether to incorporate any similar update into our law. And as a quick aside, I just wanted to mention that the DP Brexit regulations have already made one change to our e-privacy regime, just to clarify that the standard of consent required under the Privacy and Electronic Communications regulations is the same standard as that required under the GDPR, so freely given, specific, informed, and unambiguous. So in summary, from the 1st of January next year, the UK's data protection law will be contained in the UK GDPR and the Data Protection Act 2018 as amended by the Data Protection Brexit regulations. Now let's take a quick look at those regulations and just consider how they amend both the UK GDPR and the Data Protection Act. And I'm going to move through these key points fairly quickly because we'll talk about some of these issues in a little more detail in a practical way a bit later on. So looking firstly at the UK GDPR, just remember in terms of material scope that the UK version of the GDPR is broader than the EU GDPR, but this is unlikely to impact commercial organisations. On territorial scope, and we'll come on to look at this, the scope of the UK regime is essentially a mirror image of the EU regime. So the UK asserts extended territorial scope just as the EU does, and this will lead to some overlap, which we'll discuss. In relation to the appointment of representatives, the UK's approach is similar to the EU approach. Let's just pause for a minute on international transfers. In relation to these, the Secretary of State can designate a third country or international organisation as providing an adequate level of protection for personal data under the UK GDPR. The Secretary of State will be required to consult not with the EDPB but with the ICO. And the Secretary of State can also approve standard contractual clauses and can delegate this task to the Information Commissioner. The DP Brexit regs revoke existing adequacy decisions of the EU and standard contractual clauses, and they insert instead transitional provisions into the Data Protection Act, which are intended to ensure the free flow of data, but for a transitional period. And these will be subject to review in due course. But the fact that these have been addressed already means that from a UK perspective, data can continue to flow to adequate jurisdictions using standard contractual clauses, just as the data could flow under these mechanisms under the existing regime. So, of course, that means that although the UK has already sought to address transfers from the UK to the EU, the UK can't legislate to permit data flows from the EU to the UK, and these will continue to be subject, of course, to EU GDPR controls, and this is really a key issue for organisations to think about. David will talk about this shortly, but just to give you an example of the potential difficulty, consider a UK company using a cloud service provider hosting data in, say, the Netherlands. So following the end of the transition period at the end of the year, and assuming there's no adequacy for the UK, then even if the UK company could continue to send its personal data freely to the Netherlands under UK law, of course, the Netherlands could, I'm not saying it would, but it could impose restrictions on the company from accessing its own personal data, because that would be a transfer of the data from the EU to a third country, i.e. the UK. So this is, I'm certainly, just to repeat, not suggesting that this will happen, but I'm just saying this is the kind of issue that organisations need to think about and take steps to accommodate. Just then returning to the list, the Information Commissioner, you need to note that the ICO's role will change from the 1st of January. And so to reflect these changes, the Brexit regs remove a swathe of Articles 60 to 76 of the EU GDPR from the UK GDPR. And then otherwise, there are a number of really what I would describe as housekeeping amendments so that the UK GDPR works as standalone UK legislation. And there are some other amendments that make the UK GDPR fit with the DPA. So, for example, in the UK, the age for children's consent is 13 and not 16 as provided by the EU GDPR. So in the UK GDPR, Article 8 has been amended so that children's consent to information society services is 13. Moving on to look at the DPA. So I'm not going to make any comments in relation to material scope or territorial scope, but on international transfers, I just wanted to mention here that this is where there's a clear example of the need to read the DPA alongside the UK GDPR because the provisions on international transfers actually are contained in both pieces of legislation. So in the DPA, there is a new section 17A, which gives the Secretary of State power to make adequacy decisions subject to review every 4 years. Section 17B makes it clear that there is an ongoing obligation to monitor developments in relation to any adequacy decisions that have been given. So it's not just a one-off decision point. And the Secretary of State, as I said earlier, has the power to issue standard contractual clauses. There is a lot more detail on adequacy decisions and standard contractual clauses included in a new Schedule 21. And this is a particular area where the UK GDPR and the UK DPA need to be read side by side. There are additional provisions that deal with the role of the ICO after the end of the transition period, and the provisions that deal with the ICO's role in the EU are simply deleted. In relation to penalties, the change here is to convert the penalty amounts, the upper penalty amounts, into UK currency, so into sterling. So the upper limit for the higher maximum amount is 17.5 million sterling and 8.7 million for the standard fine. This is just a straight conversion. As an aside, I just wanted to note that the ICO is currently consulting on how it will calculate fines. Presumably, this is prompted by the recent experience with the BA and Marriott fines. So for anyone who's interested in commenting on the consultation, this is still open until Thursday, 5 p.m. UK time, and you can find the consultation on the ICO's website. It's a short survey, so it doesn't take a great deal of time to complete. And for anyone who is a member of the Centre for Information Policy Leadership at Hunton, we've worked with the CIPL team to prepare a detailed response, and we'll publish this on our blog for everyone in due course. There are also just a small number of additional amendments to tidy up the text, and as I said earlier, to make sure that the two texts work well together. Now, before I hand over to Rosemary to talk about adequacy, I just want to take a brief look at the role of the Information Commissioner and consider how this will change. And just very quickly, we're often asked about the role of the ICO during Brexit. And the statutory provisions that set this out are actually quite complex. So in summary, during transition, the UK has not been able to participate in decision-making and governance of the bodies, offices and agencies of the EU. So that includes the EDPB. But through an exception, the UK is allowed to attend meetings of agencies in certain circumstances. The result of all of this has meant that during transition, while the ICO is no longer a member of the EDPB, it has been able to remain a lead supervisory authority, and it still plays a part in the consistency mechanism. However, all of that will change in January when the ICO will no longer have any formal role in Europe. Its focus will continue to be domestic, but it will also focus on the broader international data protection community, including the US. And then finally, one further point to note is that as the UK won't be part of the EDPB from the 1st of, or the consistency mechanism from the 1st of January, It's possible that in the event of enforcement action, a company might find itself facing investigation by both the ICO as well as an EU regulator, and possibly 2 sanctions. Now, there have been informal remarks made about cooperation between the regulators, but nothing formal yet, so we'll need to wait and see what eventuates on that front. So that's a brief scene-setting overview. I'm going to hand over now to Rosemary to talk about the all-important issue of UK adequacy.
Thank you. Thank you very much, Bridget, for that very helpful run-through. Just as I start, could I just say to participants, if you need your attorney CLE code, it will be coming up during my session. I'm not sure how I got lucky and got the code, but perhaps if you need to write it down, if you could make sure that you've got a pen, it will make it easier. Very quickly, just on adequacy, I call this the adequacy conundrum. We should perhaps just refresh the basic prohibition on transfers outside of Europe under the GDPR, mirrored in the UK GDPR, unless there is a finding of adequacy for an entire country, jurisdictional territory, which is far the best mechanism for business to work with, or secondly, there are appropriate safeguards in relation to individual transfers, such as binding corporate rules or the use of standard clauses, but these require individual action, or there is reliance on the derogations, which are very narrow. So in that context, an adequacy application, which would, a successful application, which would allow the free flow of data to and from the EU and the UK, is hugely important. This shows the timescale. You may look at it and say, why didn't they do it in 2016? Why has it only happened now? But as Bridget has explained, the UK has only just left the EU last year, and you can't negotiate with yourself, you can't make an application for adequacy to yourself. So until the UK had left, there could be no adequacy application or indeed trade talks. Although this slide has the Commission recommendation where the negotiations include consideration of UK adequacy, in fact this is qualified by the proviso, in inverted commas, providing the relevant conditions are met. Because the trade talks and the adequacy application are separate processes. The adoption of an adequacy decision needs a proposal from the Commission, an opinion of the EDPB, approval of the EU countries. So it goes through a separate formal process. We have provided a link on this slide to the UK framework documents, all 18 of them, which in effect make up the UK's application for an adequacy finding. Now, the political aim may be to dovetail the commercial negotiations and the adequacy finding, but there is no guarantee of that. It is possible we will see a trade deal from 31st of December 2020, but no adequacy decision for several months. And indeed, if the two are wrapped up in one another, it might raise a risk of subsequent successful challenge if a view is taken that that adequacy finding was a bit of a fudge and not properly based. Current situation of the application is very unclear. Everyone seems to be being tight-lipped about it. Indeed, there might be people out listening who know more than we do. But even if we do get an adequacy finding, there is already a recognition that it may not be forever. And I've just flagged this very last box here. The issue comes up in a Commission document about frozen data. Frozen data is not nearly as tasty or interesting as frozen yogurt, but it is personal data which was obtained or processed relating to EU subjects before December 31st. So it's personal data on EU subjects subject to GDPR in the UK. And we have an obligation to continue to treat this data in accordance with GDPR, whatever happens. And the Commission website, there's a little note in there that says, even if the adequacy application is successful, in case where the adequacy decision was annulled or repealed, the UK shall ensure that the frozen data will be subject to essentially equivalent standards of protection. In other words, it acknowledges that adequacy may not be forever. So if we move on to look at the nature and effect of potential challenges to adequacy, we flagged here two broad categories of cases, really. The first is that there is a legal challenge in the Court of Justice of the EU. The second, and this has never happened so far, is that an adequacy determination is actually repealed as a result of a Commission review of UK law. Now, the first one, specific challenges, looks familiar. We have seen the plight of safe harbour, the data retention direction, the privacy shield. The other one has not yet resulted in overturning an existing decision. But under the strengthened GDPR and beefed up powers of the EDPB, this might be more of a threat. And the last point I've made is this: what happens, what's the difference between it being annulled or repealed? Well, first of all, the CJEU can actually annul a decision of the Commission. And that might mean it could be determined to be void from its outset. There is no clarity as to what effect that would have in relation to transfers which had already taken place. Or an adequacy decision can be repealed, usually from the date of repeal. The European Commission can only repeal or suspend or amend an adequacy decision. It cannot annul its own decisions. So when might an adequacy decision be challenged? The nature of the challenges, if we can move on to the next. Okay, moving back to our challenges. And this will link to some of the points that David will talk about in relation to transfers. We've got two real possibilities: direct action by individuals, for example, in the Schrems challenge to the EU Safe Harbour and the Privacy Shield, or the cases recently brought by Privacy International and La Quadrature du Net in the CJEU decision on the 6th of October about bulk access to retention of communications data, or action by supervisory authorities which actually decide to block transfers. And those are not those may well be melded together, because it may be you get a complaint to supervisory authorities and so on. But I would just flag this little point at the end, that there has been, over the past few years, a row of cases going to the CJEU in relation to UK security, access to personal data, communications data, where it is then used for crime and security purposes. And it may be that from privacy activists, this will be an area of early challenge. Moving on to what would happen on a Commission review, the implementing instrument for an adequacy finding must include a mechanism for periodic review at least every 4 years to take into account relevant developments in the country. And indeed, there is an ongoing review provision. So what would be reviewed are the same areas as were taken into account in deciding on adequacy in the first place. law, norms in the country, redress, independent supervisory authorities, international commitments. The issues are wide-ranging. So what I'd like to do is move into where we might have vulnerabilities, what might affect a Commission review. Now, I've put these as intentional, unintentional, or inadvertent. It's like some things are born to diverge and some achieve it, and some have it thrust upon them. What I'm positing here is the possibility that UK law, either statute law or case law, moves away from European GDPR norms and rules. And as a result, there is a finding that the adequacy decision no longer can be supported. The first one, an intentional policy or political or even decision of the courts to diverge from GDPR norms. It's really difficult to call a political future, of course, but it does seem unlikely that we would be so directly ready to undermine an adequacy decision, which will be very precious. And indeed, the courts, I think, although senior courts can move away from EU case law and can overrule it, one would imagine would be very cautious again about doing something which potentially would have such commercial consequences. But if we look at the second, I think the parallelogram rather than a box, but I would stand to be corrected, decisions in other areas of policy could impact on data protection law. For example, we have a consultation in the UK on a national data strategy, and one of the suggestions is freeing up data held by the public sector. Now, that might raise some alarm bells. We also have suggestions on digital regulation, online harms regulation. These interface with data protection. And as many of us will be aware, sometimes you can have an unintended consequence. And then the final point that I have made, I've just had a wonderful little note that says they're trapezoids. Thank you so much, and I shall remember that in future. The final point is around court decisions, and I've called these inadvertent disclosures. Now, that is almost saying we're going to divert from decisions not yet made by the CJEU, and it may sound odd. But I'd like to just point out some of these factors around this. And the first are the many, many issues and ambiguities around GDPR interpretation. Many are being litigated in EU national courts. We have a case at the moment, a case against Google actually, where the question is damage suffered by individuals. What is it? What does it consist of? And there are cases going on all over Europe. Secondly, think of how some CJEU decisions have taken us by surprise. Safe harbour, knocked me down with a feather. The right to be forgotten, I simply didn't expect. The CJEU does not necessarily always go where we expect it to go. Now, timescales. How long does it take a decision to go through national courts and up through in the UK to the Court of Appeal or to the Supreme Court? It's faster than it takes for a case to go to the European Court, because to go to the European Court, it has to have gone through the national courts before the reference is made. And the last point I'd make about how fast-moving this area is. An issue might be decided one way in the UK and seem fine, in line with jurisprudence and thinking. 2 years down the line, we have a new business model, which means there's a different slant on the same issue, and the CJEU goes in a different direction, wholly understandably. Now, this is very much speculation, but sometimes it's useful to put in place a fail-safe or some kind of option that you can use if that does happen. And ideally, it would be good to see a fast-track mechanism in UK law to bring us back into line. As it stands, the UK exit legislation, as Bridget has explained, does not have that. And just as a contrast, in our UK Human Rights Act, we have a provision where courts can't overrule the legislation, but they can rule that law is incompatible with convention rights. And then there's a provision in the Human Rights Act that gives a fast-track option of a remedial order which ministers can use to amend legislation which has been declared incompatible. I think that would be a useful safeguard, but I don't think we've moved in that direction at this stage, and politically I assume it would be difficult. So yes, we very much hope that we will get adequacy, but we do have to, when we get adequacy, regard it as an ongoing obligation to maintain our law at GDPR standards. And I think there's an additional message here. We do need to continue working as a community to develop resilient mechanisms for transfer, certification, codes of conduct, robust clauses, because adequacy might not see us all the way through. And that is an ideal place to hand over to David, who is now going to take us through transfer mechanisms and other challenges. Thank you.
Thanks, Rosemary, for these enlightening insights into the adequacy conundrum. Taking into account the insights with respect to the adequacy decision Rosemary shared with us just now and the fast approaching end of the transition period, it's now really time for businesses both in the EEA and the UK to start preparing for the likely scenario of a Brexit without an adequacy decision for the UK. I will talk a bit about navigating data transfers from the perspective of businesses in the EEA post-Brexit, and I will then turn the floor over to Bridget to provide some additional insights from a UK perspective. Okay, so in the event of a no-deal Brexit or a Brexit with a deal which does not address adequacy for the UK from a data protection point of view, the UK will, as of the 1st of January 2021, be considered a third country that does not ensure an adequate level of data protection. From that point in time, transfers to the UK will need to be treated similarly as transfers to any other non-EEA country that is not considered adequate, which is actually the situation for most non-EEA countries, as only 12 countries have been granted an adequacy decision by the European Commission so far. This means that businesses that send data from the EEA to recipients in the UK will need to ensure that a valid transfer mechanism is in place, which is designed to protect data after it has been transferred outside of the EEA. In exceptional cases where it's not possible to implement appropriate safeguards, businesses may be able to rely on one of the derogations set forth in Article 49 of the GDPR, such as by obtaining explicit consent for transfers to the UK, or in situations where transfers are necessary for the performance of a contract or vital interests of the concerned individuals. However, it's important to note that, as recently stressed by the European Data Protection Board in the context of its Schrems II related guidance, that these derogations are generally only available in exceptional cases for occasional non-repetitive data transfers. In other words, as any other derogation to a general rule, the derogation to the general transfer restrictions under GDPR are to be interpreted narrowly. Therefore, these derogations will generally not help businesses with structural data flows to the UK, which is to a certain extent understandable, because there are no real data protection safeguards when data is transferred based on one of the derogations listed in Article 49 of the GDPR. It is important to note that both new data flows to the UK post-Brexit, as well as any existing EEA UK data transfers, will need to be covered by a valid data transfer mechanism or a derogation after the end of the Brexit transition period, unless there's some kind of unexpected evolution in discussions around the adequacy decision for the UK. The deadline is approaching fast, and businesses will therefore need to, if they have not already done so, start mapping their data flows to the UK and adjust their existing transfer strategy and related mechanisms, or implement new ones if necessary. What we're seeing in practice is that many companies are actually combining their data flow mapping efforts that they are doing in response to the Schrems II ruling of the Court of Justice of the European Union, which also forced many companies to reassess their data flows and the related compliance strategy, with the efforts that are required to remediate transfer gaps resulting from Brexit. In relation to the Schrems II ruling, I also wanted to mention that following this ruling, organizations that are transferring data to recipients outside the EEA need to carry out a transfer risk assessment that, in addition to the risks related to the specific transfer at stake, also takes into account the level of protection offered to personal data under the legal framework of the country where the recipient is located. And, given the similarity of the EU and UK legal framework with respect to data protection and human rights in general, at least in the immediate aftermath of Brexit, it should be possible for companies to conclude that the UK offers an adequate level of protection. However, as Rosemary already indicated, this may change if both regimes drift apart through case law or regulatory or legislative actions, or even relationships with other third countries, such as the States. In terms of transfer mechanisms, the same mechanisms will be available to legitimize transfers to the UK as the ones recognized in Chapter 5 of the GDPR for any other non-EEA transfer. This means that companies will be able to rely on the so-called standard contractual clauses, binding corporate rules, ad hoc data transfer agreements, and when they become available, codes of conduct and certification mechanisms, and so on. The most frequently used mechanism to legitimize data transfers under the GDPR, certainly after invalidation of the Shield, the standard contractual clauses. For these standard contractual clauses, UK entities, so group entities, vendors, business partners, and so on in the UK, will now, from an EEA perspective, need to be included or moved to the importer side of the clauses. And this may raise challenges for agreements that cover data flows between multiple controllers, for example, in an intra-group context, where UK entities are both sending and receiving data, because from a UK data protection law perspective, the UK entities will still need to be identified as data exporters in order to comply with transfer-related requirements under the UK law, which Bridget will touch upon later on. With respect to standard contractual clauses, I also wanted to quickly flag that the European Commission is actually currently working on new sets of clauses to update the existing ones in light of GDPR, but also in light of the recent Schrems II ruling. Actually, the European Commission was expected to publish a draft of these standard contractual clauses somewhere this month. After that draft is being published or has been published, there will still be a review of the European Data Protection Board and the member states. So the timing for these new clauses is still unclear. And this, of course, does not make preparation for Brexit easier, as companies really now need to weigh the risk related to waiting for those new sets of standard contractual clauses, for which, as I mentioned, the timing is still uncertain. Again, against the efforts involved in putting in place the current sets of standard contractual clauses now, with the possibility of having to go through the same process again somewhere in the coming months. For businesses currently relying on BCRs, the impact of Brexit may also be significant, in particular for those that have the ICO as their lead supervisory authority. Those will be heavily impacted, as the ICO will no longer be able to act as a lead supervisory authority after the 31st of December 2020, which has a number of significant consequences. Of course, Brexit does not only impact the situation of businesses in the EU transferring data to the UK, it also affects businesses in the UK transferring personal data to the rest of the world. So, Bridget, I'll now turn it over back to you to tell us a bit about the situation for UK companies post-Brexit in relation to their international data flows.
Thanks very much, David. So I think from a UK perspective, there's not really a huge amount to add to the earlier remarks I made. But in summary, transfers from the UK to the EU can take place without any additional protections at this point because, as I explained earlier, the UK has made arrangements to recognise EEA member states as adequate, but this will be kept under review. In relation to transfers from the UK to adequate countries, so countries that are currently recognised by the EU as being adequate, the UK has already made arrangements to recognise those countries on the EU adequacy list as adequate from a UK perspective as well. So that's also helpful, and that will be kept under review too. And then in relation to transfers from the UK to the rest of the world, well, the position is just as it currently is. So transfers from here to the rest of the world need to use the existing mechanisms, so standard contractual clauses, BCRs, or derogations, with the same caveat to derogations that David made. These are interpreted restrictively. Someone has asked a question. I'm just going to take it now because it pops up at this stage, whether a UK company can still use the standard contractual clauses for transfers from the UK to a third country after January the 1st, 2021. And the answer is they are the only standard contractual clauses available here. It's very likely that the ICO will update them, or in conjunction with the Secretary of State will update them. It's probable that they are waiting to see what the Commission does with their standard contractual clauses. David mentioned those, and the timing is very tight. But if those clauses to be issued by the European Commission are fully signed off by the end of this calendar year, they will just come across to the UK as part of our retained EU law. But if they do not, then the UK will need to take steps to implement those standard contractual clauses sometime next year. So there may be just a gap there. For the moment, until then, the existing standard contractual clauses are really all that there are. And there's another question as well I wanted to pick up, which is, assuming there's no adequacy decision by the end of this calendar year, will EU model clauses be required to transfer to the UK? So answer yes, that is one mechanism. And will UK model clauses transfer to the EU? The answer is you don't need UK model clauses to transfer to the EU because the UK has recognised the EU as adequate. I'm going to move on, especially given time constraints. Okay, so let's just look now at, there are two more points I want to cover. One is really this issue around territorial scope and which law, and the second point is, do you need to appoint a representative? Just very quickly on this slide, you will see that the UK GDPR mirrors the EU GDPR in terms of territorial scope. So it's going to catch an established controller or processor, and also one that is not established but processes the data of, in our case, EU, in David's case, EU subjects who offer goods, to whom they're offering goods or services or monitoring their behaviour. So there's a mirror arrangement there, and we'll come on and look at this shortly just with an example. Remember too that the UK GDPR has a slightly broader scope, and I just wanted to call out that in particular because I know there are one or two on the call who are from or perhaps interact with UK public authorities, but manual unstructured processing by public authorities subject to FOI in the UK are also caught within the scope of this. And the final box there is just a reminder of Rosemary's frozen data point. You need to make sure that you keep track of this. So moving on then to the next slide. I just wanted to look at these examples now. So let's assume for the first box that let's look at, say, an EU recruitment business based in Germany. So its business spans the EU, it has corporate clients in the UK, it works with the EU and with UK candidates, and it actively markets its services to the UK and has no plans to change its model after the end of this calendar year. So as an EU business, it's going to be subject to the EU GDPR. After the 31st of December, it will also be subject to the UK GDPR and the Data Protection Act here, where it processes the personal data of UK candidates and UK business contacts of its corporate clients. So in other words, it would need to comply with both the EU and the UK GDPR regimes, including implementing a data transfer mechanism for the transfers from Germany to the UK, but remember, from UK to Germany, if a transfer mechanism is required, that transfer could take place on the basis of adequacy. The second example, let's consider a sporting goods manufacturer in the UK who sells directly to EU consumers via its website. So it doesn't sell directly to UK consumers. So at the end of the year, it's going to need to ensure that it processes the personal data of its EU consumers in accordance with the EU GDPR. So it's a continuation of the current position. It might not need a data transfer mechanism if it's dealing only with consumers, but this would require closer examination. And then note that even though it doesn't sell to consumers in the UK, it would still need to comply with UK GDPR in processing its employee personal data and the data of any business contacts at UK suppliers and if there are any UK customers. And then the third example, assume we're looking at a US hotel chain with properties across the EU and in the UK. It has a website hosted in the US and a US-based reservation system. Hotels in the EU are owned and operated by a French subsidiary. So the business will need to consider compliance with both the EU and the UK GDPR. The French, so that's the US business, the French subsidiary may also need to comply with UK GDPR as well as the EU GDPR, and the facts would need to be considered in more detail to determine whether there's a UK branch or office which is subject to the UK GDPR. So this is more complex and it would need to be closely examined, and transfers would also need to be closely examined. So I would just say that as matters stand, there's very close alignment, as we've said, between the UK and the EU, with some permitted local differences, and we just need to keep an eye on the extent to which these change or increase in future. What is critical is that organisations really take stock of their data assets and their data flows and understand which laws apply to which buckets, because that's where there may be changes. In particular, the UK bucket is likely at the moment to be part of the EU bucket, and it needs to be extracted. Right, let's move on to the next slide and just quickly look at the appointment of a UK representative. So again, there are mirror image provisions in the UK GDPR and the EU GDPR setting out when a representative needs to be appointed, and this is a question we are asked fairly frequently at the moment. So a representative may be required where there's a non-established controller or processor, so that's one without a branch, an office or an establishment, and where that entity offers goods or services or monitors the behaviour of individuals. So there are 3 exceptions to this, however, where the processing is occasional, where it's low risk, so unlikely to result in a risk to the rights of natural persons, having regard to the full nature of the processing itself. So just applying this then on the next slide, just staying on the slide, applying this to the case studies that we just looked at, if we go back to the German recruitment company with its well-established UK business and presumably frequent processing of UK data, that is probably going to have to appoint a UK rep. The UK sports goods manufacturer who sells directly to consumers across the EU will probably only collect low-risk transactional data. So absent other facts, that manufacturer might not need to appoint a representative. And then the third example was the hotel chain, the US hotel chain with the French subsidiary. So there'd need to be a closer look at the facts in this example. But even if the French subsidiary operates the UK hotel will probably be in office, even if the business itself isn't established as such in the UK. And rather than appoint a representative, it would probably need to register with the ICO as a controller in the UK. All right, that's a pretty quick run through. I'm going to hand now to David, who's just going to finish by walking us through some of the other data protection issues that need to be considered.
Thanks, Bridget. So to close today's webinar, we wanted to touch upon the impact of Brexit from an accountability point of view by just giving a quick overview of the various aspects of a company's data protection compliance program that may need to be reviewed in light of Brexit. I'm conscious of time, so I will run through this fairly quickly. So the first aspect of the company's data protection compliance program that will be impacted by Brexit are all transparency-related materials. Under the GDPR, organizations are required to include information with respect to transfers to non-EEA countries and the mechanisms that have been put in place to legitimize such data transfers in their external-facing privacy notices. So these will need to be updated to make sure, or reviewed at least, to make sure that they cover data flows to the UK. Another potential change to the data subject-facing privacy notices is in case a local or a data protection representative must be appointed pursuant to Article 27 of the GDPR, that representative's identity and contact details will also need to be included in the privacy notices. Another point to review or to take into account are the internal data protection related policies. So there may be certain cosmetic changes necessary to the internal data protection related policies to make sure that, you know, the scope and the applicable law definitions are updated in light of Brexit. And some policies may require more substantive changes. For example, policies with respect to notifying data breaches and responding to data breaches may be impacted by the fact that, you know, a company may no longer have the same setup under the one-stop shop regime. There will certainly be some contract-related work. Again, some of it will be very cosmetic changes. Other will be more substantive, in particular in cases where there's, you know, no transfer mechanism at this point in time, as I mentioned before during the webinar. Another point in terms of accountability are the data protection impact assessments. So existing data protection impact assessments may need to be reviewed to reflect transfers to the UK. And there's also a chance that new DPAs may be required for existing processing activities that initially did not trigger the need for conducting a DPIA, but now require one due to the fact that there's a transfer to a non-EEA country. We also mentioned ROPA, so registers of processing activities. Here, you know, these registers will need to be looked at to make sure that the international data transfer section is updated to reflect data flows to the UK. And the last point I wanted to mention is potentially an impact of Brexit on the DPO function. So Brexit may trigger the need to reassess the setup of the DPO function if it is currently located in the UK, as the European Data Protection Board did indicate in its DPO-related guidance that there's a preference to have a DPO located in the EU unless there's specific circumstances that justify the choice of having a DPO elsewhere. With that, I'll turn it back to you, Bridget.
Thanks very much, David. And I'm just going to wrap up. But before I do, just a quick point. I would just say from a UK perspective and thinking about accountability, this is increasingly a focus in enforcement action in the UK. And we find that when investigating a complaint or a breach, the ICO will utter these three words: show us how, which of course means demonstrate how you are complying. And so accountability, the importance of accountability can't be emphasized enough. So that brings us then to the end of our discussion this afternoon. We had a lot to share. We've taken some of your questions. I'm conscious we haven't taken all of them, but we'll try to get back to you on those. In summary, I would just say that dealing with Brexit is not easy, particularly as organisations are also juggling Schrems, and we have the backdrop of the pandemic. So it's not an easy time. There is a lot to do. I hope that this discussion this afternoon has given you some fresh thoughts and some ideas about remaining steps that you might still need to address. Thank you again for joining us. Please visit our privacy blog at huntonprivacyblog.com for the latest developments on these issues, and also to get the code, the discount code, if you want to buy Rosemary's book. And we also deal with other privacy and data protection issues there. And we look forward to having you at future events. Thanks very much. Goodbye.